Then I shall introduce my co-speakers. DeAnna Beckner is an American estate planning attorney. She holds an LLM in estate planning from the University of Miami and a Doctor of Jurisprudence from the University, from the Indiana University. DeAnna has authored many articles on the introduction of the trust and analogous institutions into civil law jurisdictions. And she will mainly discuss Article 2 of the Hague Convention on Trusts. Guillaume Grisel is an international trust lawyer based in Switzerland. Guillaume holds a master's degree from Cambridge University and a PhD in international law. He is the author of several legal books and articles, and notably of a comprehensive book on the legal, tax, and regulatory aspects of trusts in Switzerland, Le Trust en Suisse, Genève, 2020. He is also vice chairman of the Swiss and Liechtenstein State Federation. He will cover two different subjects, namely trusts in digital finance and Article 6 of the Hague Convention, theory against practice and choice drivers. I've already been introduced, so I can begin my part. That touches on the concept of the analogous institutions. And I shall begin by noting that any lawyer educated in a civil law setting would easily concede that the trust is such a peculiar English institution that it cannot be properly described, let alone reproduced in civilian terms. In stating this, he would refer to the trust in the singular, rather than to trusts in the plural. And yet, English law books constantly bear the plural trusts in their title. Is that a minor difference? It is not. If you look at Article 2 of the Hague Trust Convention, you will note in the French text the words les biens du trust, les biens du trust, while the English text of the same article says the trust assets. Now, what is at stake here, les biens du trust or the trust assets, is one of the most troubling questions the civil lawyers come against when they approach trusts. Who owns the trust assets? Now, the English text of the Hague Trust Convention says the trust assets constitute a separate fund and are not part of the trustee's own estate. So, they belong to the trustee, but are a separate fund, distinct from the trustee's own estate. While the French text states that les biens du trust constituent une masse distincte et ne font pas partie du patrimoine du trustee. You see the difference. In the English sense, they form part of the estate of the trustee, but not of his own estate. In the French text, they are not part of the patrimoine du trustee. So there are two different points of view on a basic issue. The regular use of the singular, the trust, by civilians is the linguistic equivalent of the legal notion that trust assets are owned by the trust itself, as if the trust were a corporate entity. The civilian pension for entities in circumstances that an English lawyer would depict as relationships is a recurring theme in comparative law. Trusts are entities, as entities were at the root of Pierre Le Paul analysis, and that is exactly what the civilians are ready to absorb now. Watch the case of Quebec. However, there is more than the trust that meets the eye of the student of comparative law. A civilian lawyer would by instinct seek a definition of the trust to rely upon, hopefully set out in a statute, or else generally adopted by legal writers. Therefore, a civilian lawyer is put off when his search for such a definition comes to nothing. The average civil lawyer is left to vague notions as could be found in English textbooks. And that is why, and why is that? Because trusts have never been rationalized by English lawyers. Witness the fact that in most textbooks, beneficiaries are mentioned as an indispensable feature of trusts. But everybody knows that charitable trusts have no beneficiaries. Another example, the notion of gift. Textbooks say that goods are, assets are gifted to the trustee. A civilian would not see a gift there, he would see a gratuitous arrangement. The lack of rationalization has bred difficulties in conveying principles of trust law outside the world of the common law. And that has been quite evident at The Hague, where common lawyers centered the definition of trust in Article 2 of the Convention on the transfer of control over assets from one subject, the settlor, to another subject, trustee. And by doing that, they forgot the declaration of trust. The declaration of trust doesn't show any change of control. The assets are with the settlor and remain with him as a trustee. So Article 2 is basically conceptually subject to a very grave limitation. And there is another consequence of the lack of rationalization of trust law. As a remarkable English author said, Harris, Article 2 of the Trust Convention does not incorporate anything like all the features of the English trust. And then, how could we refer to analogous institutions? Analogous to what? An attempt to provide a reply was in the request made by the Commission of the European, by the European Commission to member states to identify institutions analogous to trusts. That bred replies from all 27 member states that the Commission published in their report of 16th of September 2020, where, very interestingly, certain relationships were seen as analogous to trusts by the Commission, but not by the relevant member states. One example, the Treuhand. Neither Germany nor Austria listed the Treuhand among the analogous institutions. The Commission did. This shows the difficulties of the current approach. The report released by the Commission says similar legal arrangements generally involve a mechanism where the property is entrusted to one person. Entrusted. What does entrusted mean? From a legal standpoint, from a comparative standpoint. Property is entrusted to one person who holds the title to it or manages it. Is it the same? To hold or to manage? To manage something belonging to somebody else, or to managing something that is owned by the manager himself? It is not. There are a number of key issues that are diluted into the present search for similarities. I'll give you a quick example. The obligations of the so-called trustee, are they the same in the various institutions that are thought of as being analogous? What happens when a trustee or the so-called trustee dies? What happens to the assets? And upon his bankruptcy? And more importantly, who has remedies against the so-called trustee? That is of the utmost relevance. The Commission referred to a fiduciary bond that can be assimilated to the one provided in a trust. A fiduciary bond. Does that fiduciary bond create rights in favor of the settlor or only in favor of the beneficiaries? When there are beneficiaries, and when it is what the English call a trust for purposes, where there are no beneficiaries, whom are the duties of the trustee or so-called trustee owed to? Who can sue a trustee? Not only that, it is a common statement that trusts are not contracts. And the French speaker would translate that as un trust n'est pas un contrat. But he would be wrong. Because as we all know, contracts and contrat are not the same thing. In the civil law, for instance, in France, the contrat à titre gratuit ou sans contrepartie pécuniaire. They are not contracts because there is no consideration. Therefore, it is right to say that trusts are not contracts, but that does not imply that there can be contract in France or a Verträge in Germany. All that calls for a radical new approach to the subject of the similar or analogous institutions. And my proposition is that the Hague Conference on Party International Law convened a conference where comparative law scholars would chart a theoretical institution, no matter called what, against which all the existing institutions would be matched. Trust would be only one of the many legal institutions to be considered. And the gist of the conference would be to provide the conceptual basis for a renewed convention that would supplant the current trust convention. Thank you very much. I'm just at the end of my time, so that I will turn the speech to DeAnna without time for questions now. There will be time for questions or comments later on. Please, DeAnna, it's your turn.
Thank you so much, Professor. And I want to say thank you so much to everybody involved in organizing such an interesting panel, and especially thank you to Harry for rescheduling a better time for me because I'm over here in the States. So yeah, thank you again to everybody. Thank you, Professor, for moderating in such a great introduction. Like I said, I will be focusing on Article 2, and as the professor so poignantly laid out, some of the problems with whether these minimum minimum requirements of article of recognition for Article 2 specified in the convention really provide sufficient clarity. And like he laid out some of the problems, and I'm going to try to, from an American point of view, state some of the ways that I could see that we could solidify some of the trust and analogous institutions around some of the basic principles that we've developed in American trust law to clarify what a trustee is and clarify what a trust, or excuse me, what a trust does and what a trustee is. Like the professor was saying, there are some assumptions that Article 2 has been based on. As he pointed out, the Article 2 states that trust refers to legal relationships created inter vivos on or on the death by a person, the settlor, when assets have been placed under the control of a trustee for the benefit of a beneficiary or for a specified purpose. And the Article 2 goes on to state, as he said, the assets must constitute a separate fund. They're not part of the trustee's estate. Title to the trust assets must stand in the name of trustee or another person, and the trustee has the power of duty in respect to act in accordance with terms of trust or special duties imposed on him by law. As we know, the article goes on to say the reservations of settlers by certain rights or powers, and the fact that they himself must or may reserve the rights of a beneficiary are not necessarily inconsistent with the existence of the trust. Now, we know this to be true, but we also see that, as the professors pointed out, there are certain assumptions laid out that the Article 2 doesn't take into account. Number one would be that, like he said, they don't take into account the declaration of a trust, which it's basing an assumption that the trustee and the beneficiary are not, the sole trustee and the beneficiary are not the same person. Also, it takes the assumption that the trustee actually has duties to perform, which may not necessarily be the case under the trust terms, and that that there's a definite beneficiary. And like the professor was saying, there's somebody there to hold the trustee to these duties. And the first thing I would touch on is what we refer to in the States over here as merger, which is, like I said, when the sole trustee is also the sole beneficiary, we know that the equitable and legal titles would merge, and the trustee would owe no other duties to themselves. So we would have the trust merge, and therefore I would argue that this would be one of the things, a basic definition of a trust or analogous institution, that if a trust has a sole trustee who's also the sole beneficiary, that would merge and no longer be a trust. And then the second would be the idea of a passive or dry trust, which, as we see in Article 2C, the convention, as I stated, says that the trustee must act in terms of the trust or duties imposed on by law. But like I said, what if there are none? And we would refer to that as a passive or dry trust, because the trustee, like I said, has no duties to perform. And there's no way to hold the trustee to these duties because there's none to perform. So therefore, the beneficiary should be able to acquire the title of the trust property, legal title of the trust property, because there's no way to make the trustee to account. And that also brings us to what the professor was talking about. What is a fiduciary bond? What does it mean to act, to hold, or to manage? And what I would say is that we would need to, maybe in this next commission that the professor is suggesting, that we look at to add a list of fiduciary duties. Under American trust law, we have a long list of fiduciary duties that the trustee must be held to, or else they will be able to be sued, as like the professor was saying, for breach of trust. And I think, like the professor once again was saying, is that the lack of the clarity of what a trustee is must be defined. So therefore we can understand what a trust does. And so therefore, when you look at the Universal Trust Code of some of these duties that we require the trustee to be held to, or you look at basic duties that I feel like any trust or any analogous institution would be easy, would be easy to meet, which, you know, first, duty to act in good faith, duty of loyalty, duty impartiality, duty to prudent administration, duty to inform. These are all things that the trustee would be held to account, if not the trust terms. Now, most trust terms in the United States do actually spell these out, but it is because we have these universal trust code. So I feel like the professor was saying that if we could come around and solidify some of these basic principles, and I believe these duties of the trustee would go a long way to be able to, like I said, solidify the definition of what a trustee must do and what a trustee cannot do, and then therefore what a trust actually does. And like the professor was saying, is that you have to have somebody to be able to hold this trustee to these duties. If you're going to make a list of long duties of the trustee to be held to, we have to have somebody to be able to hold the trustee to these duties. And that's where we get into the idea of having a definite or ascertainable beneficiary, somebody that actually is ascertainable, somebody that we can find, that we know that is living, whether it be a corporation or a person, but somebody that is definite, that we can say this person holds that trustee to account. And I think with the trustee being such a crucial role and to the function of a trust, like I was saying, this only makes sense to clarify the function and be able to create more stability and predictability in the institution of trust and its analogous institutions. And just in conclusion, like I said, I hope it's not too forceful to me to try to force these ideas of American trust law, but I just feel like it goes along with what the professor was saying, that if we can form a basis of what trusts or analogous institutions are and match them up with these certain requirements for the creation of a trust, it would go a long way to clarify what a trust is and creating predictability and certainty in those institutions. Thank you.
Thank you very much, DeAnna. Should there be questions or my presentation or DeAnna's presentation, they can be put forward now. If there are no questions, then Guillaume, it's your turn.
Thank you very much, Professor Lupoi. And thank you very much to the organizers of this conference. Can you hear me correctly? I assume it's the case. I'll address two totally different topics. First, the possible role of trust in digital finance. And second, the choice of trust law in the real life and the current trends in this regard. Let's start with digital finance. In finance, there's always a need for confidence between the players. It's traditionally the role of the law to guarantee this confidence. But with the blockchain technology, it looks like we're trying to replace confidence in the players with confidence in technology, particularly in decentralized finance. If we no longer need trust in the players, does it mean we no longer need law? Well, if you listen to some computer scientists, it seems so, but it's not true. We can already see the first technical malfunctions and frauds. Consequently, there's a need for law and for liability. I think digital finance players are starting to realize that doing without law is a myth, and they're wondering what legal tools to bring in to make digital finance workable, even if it is less perfect than initially expected. Of course, one possibility is regulation, but digital finance has an aversion to regulation. It prefers to turn to private law tools. And naturally, when it comes to creating trust, we think of the trust. More and more players indeed wonder if the trust could be the panacea. So what do we think of that? The question is quite complex. we first have to distinguish between centralized and decentralized finance. Traditional centralized finance is based on the intermediaries, banks, credit card networks, etc. Financial transactions happen through these intermediaries. Now, digitalization and blockchain have not made centralized finance disappear. On the contrary, most of the cryptocurrency transactions happen via centralized cryptocurrency exchanges. But the blockchain technology has also opened the way to so-called decentralized finance, a financial system without intermediaries, where economic players can carry out financial transactions directly with each other. Now, the role of trusts is not the same in these two systems, and the legal challenges are not the same either. In transactions through centralized cryptocurrency exchanges, users give up the ownership of their values to the exchangers. So the exchanger legally owns values without being a beneficial owner of these. In common law jurisdictions, courts might regard this arrangement as a trust, but probably not civil law courts. This situation raises questions of legal classification. Is there really a trust? But also of recognition. If there's indeed a trust, will it be recognized as such in other jurisdictions? And that is important for two reasons. First, digital finance is global, so it needs global recognition, otherwise it doesn't work. And second, we're talking about currencies. A currency is nothing without recognition. Recognition not only of the value of the cryptocurrency itself, but also of the legal arrangements for transactions. Now, can the Hague Trust Convention help with these issues? Perhaps not as much as we'd want. For one thing, the list of states parties is much shorter than the list of states where people use cryptocurrencies. Then all kinds of difficulties can already be anticipated. For example, there may well be legal arrangements that qualify as trusts in crypto transactions, as we said before, but they may not always qualify as created voluntarily and evidence in writing, as Article 3 requires. Now, what about decentralized finance? The questions to address are a bit different here. Decentralized finance is based on the blockchain technology. Transactions are verified by so-called miners and recorded in blocks. Now, in theory, this implies three things. There are no mistakes, there's no need for intermediaries to make the system work, and nobody needs to be held liable because there are no mistakes. Now, if there's one thing that legal experts know, it's that whenever human beings are involved in something, there are always mistakes at best and fraud at worst. There's often a bit of both, by the way. And indeed, we can already see the first IT and honesty problems appearing in DeFi. Digital finance players are increasingly approaching lawyers to see if the trust can be used to avoid or fix these problems. Why not? But the first question that jumps to mind is, who would be the trustee? I can see 4 options, but there may be more. Option 1, the miners. But this doesn't work because miners only verify and validate transactions. They never hold the values themselves. Option 2, the cryptocurrency issuers. The tokens could be structured in the form of unit trust, and the units could be held in trust by the issuers. This might pose some trust law challenges, but it can be considered. Option 3, creating new entities that would be responsible for the transactions and that would hold the exchange values as trustees. Now, this is okay too, but on closer inspection, it would simply mean a return to some sort of centralized finance, wouldn't it? Option 4, why not consider that the users, the investors, are trustees for each other in flawed transactions? This makes sense, but we would have resulting trust or constructive trust here, not voluntarily created trust. Would be in the area of legal remedies. Now, there are so many other questions, like how can the anti-money laundering due diligence obligations of trustees be integrated into the mechanisms of decentralized finance, etc. So as you can see, we're still at a preliminary and exploratory stage. Many intelligent people will still have to think about these issues, both from the legal and the IT side, before we can come up with optimal solutions. Now I come to my second topic, the real life of the choice of trust law. Thanks to Article 6 of the Hague Convention, it is possible to choose the law applicable to a trust. It's perhaps the most spectacular provision of the treaty, because countries that don't even have their own trust law can suddenly offer not just one, but dozens of different governing laws to the people who want to create a trust. This possibility has been exploited in a very lively way in countries such as Italy or Switzerland, for example. Now, we're evaluating the effectiveness of the convention. As part of this exercise, I believe it's very interesting to look at how the choice of law system operates in practice, in reality. I conducted a small survey among trust practitioners and professional trustees, mainly in Switzerland, and it appears that Article 6 lives its own life in a way perhaps quite different than initially expected by its drafters, at least in two respects. Firstly, the person making the choice, and secondly, the choice drivers. Who really makes the choice of law? According to Article 6, a trust shall be governed by the law chosen by the settlor. But in the real life, it is often the trustee who chooses the applicable law. Why? Because the settlor has no clue, whereas a professional trustee knows what he's talking about and what he wants. It is true that sometimes the settlor previously consulted a lawyer. In this case, he's able to make a considered choice, but it's by far not the totality of the cases. It is also true that it's the settlor who signs the trust deed, so technically speaking, it is he who chooses the applicable law. But still, this choice is often suggested by the trustee, and the settlor rarely questions it. Do we think it's good that the trustee make the choice of law, or do we think it's bad? This is actually a trust law question, and we don't have to answer it now, but it's important that we keep this reality in mind because it has an impact on how Article 6 operates. Now, let me give you a couple of examples of related problematic situations to stimulate the debate. First, it is sometimes unclear who the settlor is. If the initial owner transfers the assets to the trustee, who then declares himself trustee of these assets? Who's the settlor here? And who has the power to make the choice of law? Second example. Imagine a person that is a citizen and a resident of a country without trust law, but having the Hague Convention. This person makes a last will, providing that his assets should be held in trust after his death. No more details in the will. The testator leaves it to the trustee to work out the details of the trust, including the choice of law. Can the trustee make a valid choice of law? Should he be able to? Look, I'll stop here because these issues are literally endless. Now, let's explore the choice drivers and the current trends in terms of choice of trust law. Here are the results of my little survey. In a jurisdiction that has its own trust law, the local law will most often be preferred, even if the country has the Hague Convention. Not a big surprise. But what about the countries without a trust law? Intuitively, one might think that the law most likely to be chosen would be the law closest to the settlor or the beneficiaries. But this is often not the case. One might also think that a particular law would be chosen because it allows to give the trust some specific characteristics. And it is sometimes the case. For example, to create a private purpose trust, the law of the Cayman Islands will typically be chosen, as most other trust laws don't allow that. Or the law of Bermuda will often be chosen to avoid the rule against perpetuities. But in the majority of cases, people form fairly ordinary trusts and don't really need to choose a specific law because it allows particular options. So what are the real choice drivers? Main driver, knowledge. Professional trustees typically choose the law that they're most familiar with. For this reason, many professional trustees always use the same applicable law. And interestingly, this approach is favored by the Swiss regulator as it is considered less risky. Second driver, case law. Jurisdictions with a rich, long-standing and high-quality case law are preferred. Jersey is often mentioned as a good choice. Geographic proximity matters too. New Zealand law was once popular, but the remoteness of the courts seemed to be one of the reasons for its decline. Third driver, the interest of the beneficiaries. That's a tricky one. Because if we were asking the settlors about their choice drivers, this one would perhaps be at the top of the list. And it's all the more tricky as the interests of the trustee and those of the beneficiaries are not always aligned. Fourth driver, the preferences or the perception of third parties like the regulator, the banks, or the public. That's interesting too, because this parameter was certainly much less important 15 or 20 years ago when offshore was still trendy. So we see that the choice of applicable law is not necessarily made by the person we think, and not necessarily for the reasons we think. Does it mean Article 6 is inadequate? I'm happy to leave this question open for discussion. I hope that the somewhat raw material that I presented will serve as food for thought. Thank you.
Thank you very much, Guillaume. I will say one word about the choice drivers, since Italy is one of the countries that has made the most of Article 6.
Yes, I was about to ask you to do that.
Yes, and I mean, we are possibly the civil law country with the highest number of trusts. And my comment will concern the choice driver relating to the judiciary. You mentioned Jersey. Now, the choice we made in Italy has been to refer all litigation to Italian courts, not to the foreign courts, always to Italian courts. The reason is, it was a very wise choice. The reason is that in 95 cases out of 100, there are no questions of foreign law to be decided. The questions before Italian courts are mainly questions of Italian law, for instance, protection of creditors, or protection of family members when there is legitime, as in Italy or in France or in Switzerland. It's very unusual to have a question verging on foreign trust law. Now, when that happens, Italian judges have shown they are they have been very good studying foreign trust law. I mean, we have several instances of Italian judgments that actually refer to foreign precedents. So that would be my only comment. Guillaume is right. Civil law jurisdictions can very well make use of Article 6. My only caution would be, do not refer to foreign jurisdictions, not to speak of the legal costs. And we all know what it means to litigate in Jersey or in London, for that matter. I would rather litigate in Geneva or Lugano or Rome or Milan. Okay. Other questions? Have we all been so convincing that there is nothing to be said? Okay. Would you want to say something else, Guillaume? We've got a few minutes if you wish.
Yes, thank you very much. Well, thank you for your comments. I was hoping that you would say what you just said about Italy, because this is really a point where there are differences between Switzerland and Italy, and it's really interesting to see the Italian approach, which I was aware of. Maybe if we have a few more minutes, I've got a few other things that I would like to say, but DeAnna or Maurizio, if you have other things to say, I'm happy to share the remaining time with you.
No, go ahead. Go ahead.
Okay, so maybe just a couple of minutes on one question. One of the questions that was raised by the organizers of this conference was, how does the Haken Convention help traditionally onshore jurisdictions to become trust-friendly jurisdictions for wealthy settlers? I think this point is very interesting. Now, of course, the Convention has a role to play in this regard. This is obvious, especially in civil law jurisdictions, because a country can't have a trust industry without recognizing trusts in the first place. But I think we need to face the truth, and sorry to be trivial here. The competition between countries in the trust market is primarily a question of taxation. A country will only attract foreign wealth if it imposes little or no tax on trusts with non-resident settlers and beneficiaries. And if a government wants wealthy settlers or beneficiaries to take up residence in its territory, it will have to adopt an attractive personal tax regime for them, typically by recognizing that they are not liable to tax on the trust's capital or income. Now, this can certainly be deplored. In an ideal world, one might wish that each country had a trust industry that catered for its domestic market, and that the offshore jurisdictions catered only for truly international families. But tax competition will remain the reality, whether we like it or not, perhaps until there's a global minimum tax on large wealth similar to the GAFA tax. So to sum up, I'd say that for a traditionally onshore civil law jurisdiction to become attractive in the trust market, the Hague Convention is useful and probably even necessary, but clearly not sufficient. I don't know if you have any comments on this. All right, I don't think there are any comments on what I just said. So maybe Maurizio, would you like to go ahead with a conclusion?
Yeah, I'm sorry, I was speaking without a microphone. That's why, Guillaume, I'm sorry. I was saying precisely what you said, that if there are no questions, we hope that it has been of some use to our public, that there will be some other initiative by the Hague Conference, and if so, we shall meet again. Who knows? Thank you very much, and until next time.